Namaskar and welcome to this program. Today I will talk about the rights of the prisoners of war during armed conflict or warlike situations. And today's topic is a part of our certificate in international humanitarian law. This program is offered by School of Law, and this topic is covered in BLE 035, that is course 1. So, as you know, after the Second World War, it was realized that there is a need to limit the use of, to limit the hostilities during armed conflict. The efforts were started even before the Second World War, and especially after the First World War, but they could not succeed in preventing Second World War. And after Second World War, a number of developments took place, and one of them was the adoption of the Geneva Conventions of 1949. In 1949, 4 conventions were adopted. First convention, that is Convention GC1, Geneva Convention 1, is related to the land warfare, and second convention is related to sea warfare. It covers the situations of war in the sea, and situations of shipwrecked, when a ship is damaged and the person faces faces problems due to this situation, and sick and wounded persons. And third convention is related to the prisoners of war, and fourth convention deals with the rights of civilian population. So in the last program we covered the Convention 4, and now in today's program we will cover the Convention 3. We'll talk about the third convention, that is convention related to the prisoners of war. And I also would like to tell you that in 1977, 2 additional protocols were adopted, and these protocols in a way expanded or clarified various issues covered by these four conventions of 1949. So, what is the rationale of protecting the prisoners of war? Firstly, the treatment of prisoners of war stems from the conviction that the captured combatants no longer poses any threat to the lives of the persons who captured them, nor to the detaining powers. While specific forms of procedure of treatment may be influenced by the former conduct of the prisoners during the combat. E.g., for example, the use of prohibited weapons, attacks against protected persons, or perfidiaries. So the crux is that these people are not directly participating in the hostilities, therefore they need to be protected, because as I told you that the purpose of these conventions is to limit the hostilities. So people who are not directly participating in the war should not be, because prisoners of war are no longer a threat to anybody, because they are in the captivity. So now, what is combatant? First, we should understand who are combatant, who are non-combatant. Combatant are generally people who are participating in the hostilities, members of the armed forces of a party to the conflict, including members of militaries or voluntary corps forming part of such armed forces. These types of people, and there are other categories also, members of the other militaries and members of other voluntary corps, including those who organized resistance movements belonging to a party to the conflict and operating in or outside their own territory. So the people who are part of the regular army are generally, or the people who are who have volunteered themselves to be the part of the army, armed forces, they are the combatant. Other categories of the combatant includes that of being commanded by a person responsible for his subordinates, and also that of having a fixed distinctive sign recognizable at a distance. So these are some of the characteristics of a combatant forces. Their symbols, their identity, their emblems should be distinguishable from a distance, and they should be under the command of a person, under the command of a commander. So there should, for combatant, there should be a kind of organized forces which are participating in the armed conflict, and that of carrying arms openly. This is also the characteristics of a combatant, and also conducting their operations in accordance with the laws of the and the customs of the war. This is also an important aspect which needs to be considered. Another point to be noted with regard to combatant, because before we come to the rights, general rights which are available to prisoners of war, we should distinguish between combatants and non-combatants, because combatants are directly participating in the hostilities, so attacks on them are permissible. But people who are non-combatant, for example, people who provide medical support, or people who are providing logistics, or even the prisoners of war, because they are not participating in the war, so they need protection and they should not be subjected to any kind of attack. The armed forces of a party to a conflict consist of all organized armed forces, groups, and units which are under a command responsible to that party of the party and the conduct of its subordinations, even if that party is represented by a government or any authority not recognized by an adverse party. So it may be a government or it may be a authority or a group which is not recognized by that by the adverse parties. Such armed forces shall be subject to an international disciplinary system which inter alia shall enforce compliance with the rules of international law applicable in armed conflict. So this is also a very important aspect which needs to be considered. Similarly, the members of the armed forces of a party to a conflict, other than medical personnels and chaplains covered by Article 31 of the Third Convention, are combatants. That is to say, they have the right to participate directly in the hostilities. So these people can participate. Now, whenever a party to a conflict incorporates a paramilitary or armed law enforcement agency into its armed forces, it shall so notify the other parties to that conflict. If paramilitary forces or any other forces are incorporated, I mean they are made the part of the armed forces, then the other party should be notified. These are the things which the conflicting party should follow. It is another point that in practice many of the rules, many of the provisions of international humanitarian law, whether it is treaty based or customary, are not followed. That is a different thing, but it is expected that the parties who are participating in hostilities should follow these rules in order to promote the protection of the civilians population from the effect of hostilities. Combatants are obliged to distinguish themselves from the civilian population while they are engaged in an attack or in a military operation preparatory to an attack. So this is a common sense rule that these people should be distinguished. These people should be identified, should be distinguishable from the civilian population, so that civilian populations are not subjected to any kind of attack. Recognizing, however, that there are situations in armed conflict where, owing to the nature of the hostilities, an armed combatant cannot so distinguish himself. There may be such kind of situation, but generally they should distinguish themselves from the civilian population. And now another important point with regard to combatants is that during such time as he is visible to the adversary while he is engaged in a military deployment procedure, the launching of an attack in which he is to participate, that has to be clearly noticeable, that should be clearly indicated, and acts which comply with the requirements of this paragraph shall not be considered as perfidious within the meaning of Article 37. Now another point here to be noted, that any combatant who falls into the power of an adverse party while not engaged in an attack or in a military operation preparatory to an attack shall not forfeit his rights to be a combatant and prisoners of war by virtue of his prior activities. So this is also a very important point which needs to be considered. Now there are certain fundamental rules of the treatment of prisoners of war, which we have to take into consideration while dealing with prisoners of war. Prisoners of war are those people who are captivated during the armed conflict by adverse parties. Firstly, it is prohibited to treat prisoners of war inhumanly or dishonorably. First principle is that they should be treated with respect and humanly. Their humanitarian needs for clothing, their medical needs, etc. should be taken care of. Any discrimination on the grounds of race, nationality, religious belief or political opinions or similar criteria is unlawful. So any distinction based on the caste, religion, etc. is unlawful, because they are prisoners of war. They fought for their country or their group. So they may belong to different religion, different system, different belief. So there should not be any distinction between the prisoners of war based on religion, etc. Reprisals against prisoners of war are prohibited. Reprisal means revengeful actions on the part of the captivating party who has captivated them. Now, with regard to captivity, captivity starts when the person is captured by adverse parties during armed conflict, and during captivity their basic rights should be maintained. They cannot be asked to disclose the secret information of their country or to whom they are representing, except their badge number, their designation, etc. And their basic needs should be taken care of. They should not be subjected to any kind of forced labor or inhuman activities. I mean, they should not be employed in such industry or such places which are hazardous to their lives, their health, and their recreational requirements, their religious, I mean, their really, I mean, if they have a particular method or particular way of worshipping or for practicing their religion or their beliefs, this should be respected. So, and when the captivity ends, they should be sent to the adverse parties with respect, and with as soon as possible they should be transferred to the other parties. So these are the things which we have tried to explain to you with regard to third convention, that is Convention on the Prisoners of War, Geneva Convention on the Prisoners of War 1949. And we have tried to cover the important aspects, because in 30 minutes time we cannot cover each and everything, but we have tried to give you the crux of the convention, the crux of the protection available to the prisoners of war. So we hope that you have enjoyed our program. So next time we will cover two conventions, that is Convention 1 and 2, that is Convention 1 which is related to land warfare, and Convention 2 that is sea warfare. So provisions are almost similar, so we will cover these conventions in one program only. So thank you very much, and namaskar.